Hello. So good morning everyone and welcome to the second day of the workshop, that is Bharat 6G Vision Translating Research into Standards. Yesterday we had an incredible panel discussion and presentation by experts from various fields, including representatives from ministry, academia and also industries. Today we continue in the same spirit as we kick off day 2 of our workshop. To begin today's session, I am pleased to introduce our next distinguished speaker, Professor Arul George Scaria from the National Law School of India University, that is NLSIU. Professor Scaria will be sharing his insights on IPR in the field of ICT, a topic of great relevance and importance. Professor Scaria has an impressive academic and professional background. He earned his LLB from Mahatma Gandhi University in Kerala and went on to complete his LLM in Intellectual Property Rights at NALSAR University of Law in Hyderabad. He then pursued a PhD at the International Max Planck Research School for Competition and Innovation, where he deepened his expertise in the field. Professor Scaria is also an affiliated faculty member for the Copyright X and Patent X course at the Harvard Law School. Notably, he was the first academician to be appointed as an independent expert by the IP division of the Delhi High Court. He has authored significant work including piracy in the Indian film industry, copyright and cultural consonance by Cambridge University Press in 2014, and ambush marketing, game within a game by Oxford University Press 2008. So please join me in welcoming Professor Scaria to the stage. Thank you.
So very good morning, everyone. First of all, a big thank you to the Department of Telecom for inviting me for this session. It's always a pleasure to interact with students as well as also people who are actively involved in policy making. And the pleasure is higher when the meeting is happening at a place like IAC, maybe my most loved campus in India. So I'm really honored to be here today. So for today's session, I plan to have this discussion in kind of like 3 parts. From the organizers, I know that this is a fairly mixed group, so that's definitely a challenge for any person who wants to discuss any topic. So what we are going to do is we'll start with some of the very basic concepts relating to intellectual property rights. And as you may notice from our subsequent discussions, some of these fundamental things also have extremely high relevance in policy making. So even though they might appear to be very fundamental, yes, they also have very high relevance in terms of what policy approach we should be taking in this area. In the second part, I would like to briefly touch upon some of the questions posed by AI in this particular realm, because I think that might also be of interest and relevance for many of the people who are sitting here. And in the third part, I will be focusing more on the standard essential pattern. So this is in a nutshell what I want to actually try to do in the next 60 minutes or so. The organizers mentioned that it's a very active audience, so I want to, I think, keep up the activeness of the audience today also. So please feel free to interrupt me at any point of time. So there is nothing that tells me that, yes, I should be going through all the slides which I have. I think what is more important is to have discussions on the things which we discuss. So just raise your hand and seek clarification at any point of time. So let's start with one of the very basic but maybe a challenging question. How many of you have heard the term intellectual property rights? I'm just asking, have you heard the term intellectual property rights? Yes, almost everyone. How many of you can give me a comprehensive definition for what is intellectual property? Yes, Kunal. Yes. Ownership over some creation of mind. Yes, it's a really good attempt. Anyone else? I think only Kunal was daring to raise his hand, but is there anyone else? Yeah. It's not too surprising. See, everyone has heard the term intellectual property rights, but when it comes to the question of like having a comprehensive definition, it's very difficult, if not impossible. And it's also not without a reason, because what we generally term as or mention as intellectual property rights have expanded over a period of time. And I think it has expanded to a level wherein it's now extremely difficult to give one definition that more or less completely covers all the dimensions of different things which we call as intellectual property rights. So on the screen, you will see three definitions. Of course, among the three, I think the third one, the one which is given by the World Intellectual Property Rights Organization, is the most cited one. It says that intellectual property refers to creations of mind, inventions, literary and artistic works, and symbols, names and images used in commerce. So it's a fairly like cited definition, but to me, maybe the best definition I have come across as an academician working in this area is the one which is given by two very prominent scholars in this area, Professor Bentley and Sherman, who kind of divides this term into two parts. In the first part, they point out that yes, the term intellectual is an adjective, which is indicating the character of some of the material this area of law protects, that is, as Kunal said, products of human mind or intellect. The second is a place where I might actually differ a bit from Kunal, that is, yes, here they indicate that the term, the second part of the term is property, which is indicating a form of regulation, and this generally means grant of exclusive rights which operate in a manner similar to property rights over tangibles. The reason why I said I might slightly differ from him is with respect to whether we are going to treat intellectual property like property in all the cases. Because again, as I indicated earlier, these are enormous implications on how we generally approach this particular area, that is intellectual property. And maybe I should also explain that in a bit more detail, because this is very much important when the policymakers deal with this particular area, intellectual property, or when judges adjudicate in this particular area. So when it comes to the question of similarities with property, by property I mean things which are like tangible in nature. Say for example, you might be owning a house, so that's definitely a property. You might be owning a phone, you might be owning a car, these are property, right? So what are the similarities we are seeing with those kinds of property? So on one side, yes, like those property, most intellectual property rights can also be assigned or bequeathed, so you can actually give away to someone. It is also clear that if someone is trying to trespass into your intellectual property, yes, in many instances, you can also prosecute them. So in the case of land, house, etc. also, we know that, right? I mean, if someone is trespassing into your house, yes, you can call the police, they will do the needful to ensure that, yes, they are taken out. Similarly, in the area of intellectual property rights also, we can see that when someone transgresses into the boundaries of your protection, yes, they can be prosecuted. Then, yes, similar to the other property rights, ownership is giving an exclusive right to exploit the property or to give others a license to do so in different ways. So these are some of the similarities that forces many scholars to treat them as equivalent to property. But it's also very important for us to understand that at least from a legal perspective, there are limitations to that comparison. And this is what many a times policymakers and judges tend to forget. So the first and the most important limitation with respect to that comparison is the fact that unlike other property, here the character of consumption is non-rivalrous. Has anyone heard the term non-rivalrous character in consumption? Not many, because I understand that most of you are coming from the tech background, but if you ask an economist what is a non-rivalrous product, they will say that yes, we call that a particular product as a non-rivalrous character in consumption when one or more persons can consume the same good without affecting the possibilities of consumption by the other. Just to give you a very simple illustration there, so imagine that we are talking about a hard copy of a book. That hard copy can be read by only one person. But if I am talking about a digital copy, the same digital copy can be consumed by maybe hundreds, if not millions at the same time. So there, in the case of the digital copy, what we are seeing is that there is non-rivalrous character in consumption. So with respect to physical properties which we generally see, they have rivalrous character in consumption. But with respect to most of the intellectual property which we discuss, it's important to understand that they have non-rivalrous character in consumption. In other words, my consumption of that good may not be affecting the consumption of the same good by you or many others. The second issue is also very important. In the case of a physical property like land, house, etc., it's relatively easy for us to mark the boundaries of protection. You just need to look at the periphery of your property. Things are very clear. If someone is entering there, yes, you can throw them out. But in the case of a patent or in the case of a copyright, are the boundaries that clear-cut? Of course, over a period of time, we have developed different kinds of doctrines to create boundaries, but it is very important to know that these boundaries are not as clear-cut as in the case of most of the other tangible properties. So there is some possibility to mark off the boundaries. We'll also briefly discuss how it is being done in some instances, but it is important to recognize that the marking of boundaries is not as easy as in the case of a physical property. So that is also throwing many limitations to the comparison or analogy with the physical property. This has also led to many scholars suggesting that maybe it is wrong to use the term property in the context of intellectual property. Maybe the better terms to use is intellectual monopolies, or maybe just say that this is a right to exclude. And why is it important? The main reason is that the moment you use the term property, our approach towards that also changes considerably. In other words, when a judge is seeing the term intellectual monopoly as compared to intellectual property, the chances of him granting a remedy to the concerned owner would be very, very different in both the cases. If you are seeing the term intellectual monopoly, the chances of her upholding the right in favor of the concerned IP owner might be very different from what they might be seeing with respect to intellectual property. So these are practical implications, but of course, as we all know from the deliberations around us, these kinds of nuances generally stay with the academics. It doesn't go into the decision making, because in most of the decision making contexts, we just use the term intellectual property and we just consider them at many a times as equivalent to the physical property. It is also important to understand that there is little agreement on the scope or coverage of the term intellectual property, and generally its meaning is inferred by reference to the specific legislative context. And if you look at most of those definitions, you will also understand that they don't use an exhaustive definition, but rather they use inclusive definitions. And again, this is not surprising, because what we consider as intellectual property has been expanding, and I'm sure that it will continue to expand over a period of time. So if you really want to cover all these things, all what we can do is to have inclusive definitions. It is also very important to understand that when we call or use the term intellectual property law, we are not talking about a homogeneous body of law, but what we are doing is we are talking about a collection of distinct but somewhat related legal doctrines. For example, when we look at a patentable subject matter like patents, the kind of things that are covered there are very different from what might be covered under trademarks. So these are actually very distinct set of legal doctrines. Of course, there are some connections, and that's the only way we can even make those definitions. And all of them together covers very, very diverse subject matter. And for the purpose of our discussion today, maybe the most relevant one is patents, right? So as many of you would be aware of, the area of patents covers new inventions. And if a particular invention is meeting the requirements of patent law in a particular jurisdiction, so here I also have to mention that all these intellectual property rights are territorial in character. So if you have a patent right in India, your right is limited to the boundaries of this country. If you want to get protection in another country, say for example the United States, you have to go and take the protection there. So since patent laws are territorial in character, what you would also generally notice is that the conditions for getting a patent can also vary to some extent from jurisdiction to jurisdiction. So if you look at the Indian context, we can generally say that yes, if you want to get a patent, you have to meet the so-called requirements of novelty, inventive step, and industrial application. Apart from the fact that you should also ensure that the concerned invention is not an excluded subject matter under the Indian patent law. And I am emphasizing on that because if you look at Section 3 of the Patents Act 1970 in India, you will also see a fairly long list of excluded subject matter. For example, computer programs per se is an excluded subject matter under Indian patent law, whereas you will not find a similar exclusion under the US patent law. So depending upon the jurisdiction, what can get protected as patent can vary. But yes, this is one branch which I think everyone who is sitting here need to be aware of. And here the term of protection is 20 years, at least in the Indian context, it's 20 years from the date of filing of the application. Another area that has enormous implications for each and everyone who is sitting here is copyright. So in the area of copyright, what we are protecting is original forms of expression. For example, if you are writing something, yes, you are becoming the copyright owner there, or if you are drawing a painting, yes, you are becoming a copyright owner, and if you are taking a photo, again, you are becoming a copyright owner there. And unlike patents, wherein, yes, you have to go through a really tough examination process to become a patent owner, in the area of copyright law, the protection is automatic in character. So the moment you are writing down something, or the moment you are clicking a particular photograph, you are automatically becoming the owner of copyright in that particular work. So that's also a reason why I said, yes, this is one type of intellectual property which has enormous implication for people who are sitting here. But I should also add that whether you have a valid copyright or not will be determined or can be determined only by a court of law. So not even our copyright office can determine whether you have a valid copyright. So in the case of copyright, there is an optional registration process with the copyright office. So you can actually file an application and then they might grant a registration. But that registration is only confirming that your registration is with respect to one of the subject matters which is covered under copyright law in India. It cannot tell you that yes, you have a valid copyright. Whether you have a valid copyright will be determined by a court of law during an adjudication process. So that's also something which we need to keep in mind. Within copyright law, for different subject matters, there might be different terms of protection, but for the purpose of this discussion, maybe we can just use one example. In the case of a literary work, the term of protection is author's lifetime plus 60 years in India. And as you can imagine, this is a substantially longer term as compared to what you heard for patents. And again, that's not too surprising because the patent law is much stricter in terms of the scope of protection given, whereas here the length of protection is longer, but then the scope of protection is much narrower. Another type of intellectual property that might be of interest for many of the people who are sitting here is trademarks. Again, I mean, everyone who is sitting here is familiar with trademarks. We see thousands of them in our everyday life, and we make many of our purchasing decisions based on the trademarks. So what we are protecting here is distinctive signs that help to identify specific products or services. Again, the general principle here is that if you want to get protection, you will have to go through a registration process. But of course, there are also certain provisions in the law which will ensure that even unregistered marks can be protected at times. Another type of intellectual property that might be of interest for some of you here is design protection. Again, this was not a main field of intellectual property for a long time, but one litigation, that is Samsung, a litigation between Samsung and Apple, completely change the fortunes of this particular type of intellectual property. So here what we are protecting is the external appearance of a product. Some of you might have immediately recognized which product is shown there, so that's part of a design application. And as you can imagine, yes, that is relating to a design application filed by Apple for one of its earlier iPhones. And if someone is imitating that, yes, there is a possibility that the court might grant you remedies. So in this litigation between Apple and Samsung, the initial verdict was close to $1 billion in damages in favor of Apple, but of course in subsequent, I would say, levels, it got reduced a bit, but still, this particular litigation almost completely changed the scope of this particular area, and in almost every jurisdiction, what we are seeing currently is a substantial increase in the number of design applications. Then another type of intellectual property, which again is of very important, substantial importance for everyone who is sitting here, is trade secrets. So in the case of trade secrets, what we protect is a valuable information which is not known to the public. Again, different jurisdictions have different approaches towards protection of trade secrets. In some jurisdictions, there might be specific laws that deal with trade secret protection. But in a country like ours, we don't have a specific law, but we also sufficiently protect it through different sets of laws plus common law principles. What is most important here is that, yes, the concerned IP holder, that is the trade secrets holder, must have taken reasonable efforts for maintaining the secrecy. The protection is till the time you are able to maintain it as a secret. So if you are an inventor, one of the important choices which you will have to essentially make is, do you want to go in the path of trade secrets or do you want to go in the path of patents? From a policy perspective, I would generally say that, yes, as far as possible, we should push people to go into the path of patents, because in the case of patents, there is a teaching function involved, because we are granting you 20 years protection in return for you teaching the society what this invention is, how it works. In the case of trade secrets, we don't see that kind of a quid pro quo. So it's just in favor of the trade secrets owner. But then, as you can imagine, if you are an inventor, you will generally take a careful call on which path you want to take, depending very much on to what extent you can keep your invention as a secret. So in the area of ICT, you will generally notice that it's a mix of patents, copyright, and trade secrets, which is generally protecting the inventor. So that's also something which we need to recognize. Then there is a relatively unknown type of intellectual property in India, that is a layout designs of semiconductor integrated circuits. So here, as the title itself indicates, what we are protecting is the layout designs of integrated circuits. You will have to go through an application process to get protection here. But you would be surprised to hear that so far, India has seen only 2 registrations under this branch of intellectual property. So the first one was from ISRO, the second one was from, I think, BEL, if I recall correctly. Again, you might be asking, yes, why are people not going under this regime? My answer generally would be that people in this field doesn't really bother about this type of IP. Even in the absence of that protection, I think there are enough incentives for protection. So these are some of the types of IP which I thought is important for all of you, but please also note that there are other types of IP which I didn't mention specifically here. This includes GI, Protection of Plant Varieties and Farmers' Rights Act, etc. So if you have any questions on that, yes, we can definitely discuss about that during the break. It is also important for students to know that different intellectual property rights can coexist in a particular product. So imagine that we are talking about your phone. So look at your phone. That particular phone will be having thousands of patents protecting some of the underlying technologies. That phone will be having a trademark. There are many information, including, say, for example, the apps are protected under copyright protection. So in the same product, you will notice that, yes, different intellectual property rights can coexist. It is also important to note that intellectual property rights are separate from the physical objects in which they are embodied. So that's also one very fundamental, I would say, conceptual clarity which all of you should be having. So this was a very quick tour of some of the very basics of intellectual property rights. Do you have any specific questions relating to any of the things which we discussed so far? Yes.
Can you elaborate this example?
This one. So imagine that you are sending a letter or you are writing a letter and you are writing that letter to the person who is sitting on the right side. The moment you have finished writing that particular letter, you are becoming the copyright owner in the contents of that particular letter. So if anyone wants to reproduce the contents of that particular letter, they have to come and take permission from you because you are the copyright holder. But you have already sent that by post or courier to your neighbor. Now, the physical property, that letter, the physical property of that letter is owned by your neighbor. But the intellectual property, that is, which is the underlying content, is still owned by you. So that's the difference which you have to keep in mind here. Same is the case with respect to patents. There also we can actually think through these examples. As I mentioned earlier, for example, your phone is covered by thousands of patents. And there, yes, the protection is not on that physical property, but on the underlying invention. So that's the reason why I mentioned here specifically that when you are conceptualizing intellectual property rights, please ensure that we are viewing it separately from the physical objects in which they might have been embodied. Is that clear? Yes. Any other questions on? Yes.
I just wonder about the aviation sector.
Yeah.
Since it is dominated by this Airbus and Boeing.
Sure.
So do they manage just with the trade secret aspect, or they have patent over, say, aviation engine technology? Just it's not available to anyone. So how do they manage?
Yeah, so again, a very interesting question. So, since you're talking about the aviation industry, I should also mention something which is related, which is very important in the context of policy making. Many a times, India as a country receives complaints from the United States, which is one of the biggest trading partner, relating to enforcement of intellectual property rights in India. And if you look at those submissions, most of the times, yes, they are backing it by looking at the submissions from the pharmaceutical industry and so on. But one industry that stands out in this particular, who doesn't make any complaint, at least as far as I have seen, is the aviation industry. They generally say that, yes, we are getting sufficient protection in India. Again, the reason there is that they don't rely too much on the IP sector there. Of course, they do file patents. They also have many trade secrets. But their extent of reliance on intellectual property rights is limited, and that's primarily due to the factor which you mentioned. Their direct competition is very limited. There are like maybe, yes, of course, Airbus is there, then maybe there will be Embraer, there might also be like a couple of others, including the now emerging the Chinese one and so on. But direct competitions are less. But having said that, I must also add that many of the inventions that are having or happening in the aviation industry has applications beyond the aviation industry. And that's the reason why they would still go for patent protection, and they will still be holding many things as trade secrets. Because if they want to license it out to, say for example, use of that particular invention, say in the telecom sector, they need to have some underlying rights, and that's the reason why they would still rely on filing of patents or keeping some of the things as trade secrets. But I just want to re-emphasize, at least I haven't seen any complaint coming from the side of a company like Boeing, or even for that matter Airbus, with regard to enforcement of IP, whereas I will see many complaints or grievances coming from the side of many of the other industries. Madam, yeah. Yeah, so again, I mean, the clarity which we need to have there is that under the Indian patent law, computer programs per se is not patentable, whereas no such bar exists under the US patent law. What does this mean? So if you are going to the patent office, and if the patent office is of the opinion that this is essentially a patent just for that computer program, they are going to reject it. But over a period of time, what we have seen, including in the one of the recent litigations, which I hope we'll be discussing either as part of this lecture or the panel discussion, is that the courts are also taking a fairly liberal approach towards that bar, which is seen in Section 3K of the Patents Act. We generally now say that if there is a technical effect emerging from that particular patent, then yes, we have to view it in a different perspective. So for example, if that algorithm is used for producing a particular technical effect, that can still be under patent protection. But then there is still a debate within the country as to, do we really want to continue with that subject matter exclusion in today's world? There are two views on this. So one view would be that, yes, if you look at the inventions in the area of software, it's extremely cumulative in character. Everyone builds like in very, very, very small incremental steps. So if you have a patent protection there, it might actually be counterproductive to invention. So that's one side of the argument. But on the other side, you'll also notice that people point out the other policy issue which I tried to indicate earlier. If you don't have patent protection, what might happen is people will move into the trade secrets regime, which might even be more harmful because there is no teaching or disclosure happening there. So it's a very tough, I would say, call for our policymakers or legislators. We have to have some sort of a balance here. Maybe that's the balance which the courts are actually carving out now. So that's my general response there.
Yeah. Continuing that, intellectual property, separate from the physical objects in which they are embodied.
Yeah.
Same thing applies for patent also, you said.
Absolutely.
Okay. But if that's the case, the innovation content in the particular physical bodies, whatever he applies, the steps and all, whatever he writes on the physical entity which is sitting there, will be the property, or I'm just asking,
No.
or it is the action what he has performed on the physical body. Okay, he has put the action on that physical body and try to innovate something.
Yes.
Okay. How do you contradict between the program, whatever Madam asked just now? It's an idea that steps have been carried out, something act on the physical entity will be the patent, or it is the action that has been performed with my algorithm, whatever I say, innovatively I will put action on that physical entity. So how do we differentiate that, which is innovation, how the patent is extracted there? You said the physical object in which they're embedded is separate.
Yes.
Okay, it's a separate. So how do we compare that either in patent or IPR?
Yeah.
That's what I wanted
so
to just
maybe if I mention a bit more about the patent application process, I think that might become more clear. So when you file a patent application, yes, the concerned jurisdiction will prescribe what all things has to be included. But two things which will be seen in almost every jurisdiction is, one, you have to describe in detail how your invention works. So that's a disclosure part which is there. The second and more important part, which everyone should be aware of, is a claims part. So in every patent document, there is something called claims. And it is these claims that set the boundaries of the protection. So you might have described, say, maybe 1,000 things in your application, but then it is a claims part which will tell to what extent you are seeking protection or to what extent you have been granted protection. Now, when we are talking about the question of this physical versus the non-physical, the first thing to be also kept in mind is that you are not obliged to show any prototype to the patent office. What is important is that through your description, you need to convince the patent examiner that this is a workable invention. That's all. The patent office can never ask for bringing a prototype to the patent office, but your description has to be in that detail, and many a times this might also require drawings and other things to like completely convey what you are trying to protect, and that protection is granted based on that document alone. So even though, say for example, in a scooter which is standing outside this building, there might be like 100 different patents, we don't need to bother about that incorporation into that physical object. All what we need to look at is a patent document or the set of patent documents relating to that particular scooter, and then see which are the areas that are covered by the concerned patent. So even with respect to the algorithm example,
Yeah.
so imagine that we are talking about managing the traffic in the IAC junction. So there is an algorithm that is going to radically improve the traffic situation there. Through the description, you have to actually convince the patent examiner that that invention is novel, it meets the inventory step requirement, and it's meeting the industrial application requirement. You don't have to take a traffic signal to the patent office or to bring her or him to the junction to actually show that yes, this is a patentable invention. So it's that document which will be like conveying to the world what exactly is being protected.
So that means the physical entity will not come into picture.
Absolutely
Okay.
no. Yeah.
It is how we apply the logics.
Yes.
And it is a kind of a programming where we
You'll
have
have to explain.
described such a way that that is
Absolutely.
the patent
Absolutely.
or IPR.
Absolutely.
Okay, that's good.
Yes.
I don't know whether it is the right time to raise this one, but just wondering how to remove subjectivity in the subjectivity coming in during the evaluation process, or subjectivity which gets added because of legal jargons being used, or because of the tendency of the inventor to make the inventant claims very broad based.
Yeah, excellent question. I think this is the right time to also get clarity on that, because even for our discussion on SCPs, this might be very relevant. So when you file an application, generally, I mean, whether it's you or me, we generally would go to the patent office with the broadest possible claim. And then what happens is kind of a negotiation. So the patent examiner will tell you that, sorry, I cannot grant you this much protection because there is already a prior art which is covering so much of this. So what I'm going to do is this. So initially, again, I mean, both in terms of the number of claims which you have filed, as well as in terms of the scope of claims, there will be substantial reduction happening through the examination process. So it's generally a rigorous process, or at least it's supposed to be a very rigorous process, but maybe with more work pressure, sometimes the examiners might also not see some of the prior art and then give set of broad claims. But even in those instances, in a subsequent litigation, either that claim can get struck down or can get substantially narrowed in terms of how the court is interpreting it. So that kind of a bargaining or a negotiation generally happens through the patent prosecution process. But there is also, since you use the term subjectivity, there is also another issue there, that is a so-called problem of hindsight bias. So when a particular patent examiner receives an application, she or he is generally receiving it after 2 or 3 years of filing. So by the time she or he receives that application, it might have been very obvious to that particular examiner or persons who are skilled in that particular. That's something which the patent examiners have to consciously avoid. So generally, in most of the prominent patent offices, yes, they do impart training on avoiding hindsight bias. But yes, even if the examiner didn't do that consciously, you as the applicant need to point out that, sorry, we have to be careful about this. You have to step back 2 years and ask from that date, that priority date, was that an invention obvious to a person skilled in that particular area. So that's the way it works. So since you use the term subjectivity, I thought I should also clarify on that dimension. Thank you. Okay, let's also then quickly view, maybe in 5 minutes, since we are running out of time, some of the challenges which is posed by AI, because I am sure that many of you are dealing with AI-related issues, so it's important to also understand some of the discussions that are happening in this area. So one of the major questions that is emerging is, should patents be granted for inventions that are generated by AI? The other question, a related question could be, should patents be granted for inventions generated with the assistance of AI? Here, I am making the differentiation, and as you can see, with respect to copyright also, I ask questions in these 2 different ways. The reason being, there is also a possibility of inventions or artistic works that are being autonomously generated by AI, And that's the reason why we'll have to ask this question. And it is particularly important for a country like India because many of the reports also indicate that yes, we are going to be also heavily influenced by the emerging AI paradigm. And with respect to the patent ownership related question, jurisdictions across the globe are struggling. I think that's a simple thing which you need to know. For example, if you look at the United States, one of the most important case laws in this regard is Taylor versus Vidal, wherein Mr. Taylor had submitted a patent application wherein he claimed that the so-called DABUS, that is a algorithm which he had invented. This particular DABUS invented two inventions, and there you will notice the USPTO rejecting that patent application by saying or clarifying that only a natural person can be an inventor, so AI cannot be considered as an inventor. The matter got appealed to the district court and then also to the US Court of Appeals for the Federal Circuit. All of them also concurred with that. The US Supreme Court, when the matter was appealed, the certiorari was denied, which in effect means it is a US Court of Appeals for the Federal Circuit's position, which stands as a law in the United States now. The US, yeah. No, not the owner, but it has to be the inventor. So, for example, if you read this particular decision and also if you look at the current general position which is taken by the US Patent and Trademark Office, unless and until the inventor was a natural person, there cannot be a grant of patent for that invention. Yeah. Yeah. So again, I mean, this was one of the questions that was addressed by the UK Supreme Court because again, I mean, there was a similar litigation again with respect to the same parties before the UK courts. The matter went all the way up to the UK Supreme Court. The UK Supreme Court gave the verdict in last December. There also, the court categorically pointed out that unless and until the inventor is a natural person, there cannot be a grant of patent under the UK patent law. There, Mr. Taylor made the argument that, yes, I am the owner of DABUS, so I should be granted patent. And there, the legal doctrine which he used was the so-called accession doctrine, which is essentially saying that if you are the owner of a tangible property, then you are also the owner of anything that is produced by that tangible property. For example, if we are talking about a cow, the calf is owned by you because if you own the calf which is produced by the cow is also generally owned by cow. That's what the accession doctrine essentially tells us. In the intellectual property realm, the UK Supreme Court clarified that, sorry, that doctrine cannot be applied to the intellectual property realm because these are rights that are conferred by the statutes, and unless and until the statute makes a change there, we cannot go with that idea. So your question has been addressed very specifically by the UK Supreme Court in this particular decision, that is a Taylor versus the Control General of Patents, Designs and Trademarks. In India also, the same applicant, Mr. Taylor, has filed an application. By the way, for your information, Taylor is filing this primarily because of the academic interest. So what he has done is he has gone to most of the prominent patent offices across the globe, and India is also one of the jurisdictions where he has actually filed the application. In India, the matter was opposed in the first examination report. So when the matter came for screening, the examiner at the patent office made the following objection, and I quote, "The true and first inventor of the invention is artificial intelligence, which is not a person as per Section 2 and Section 6 of the Patents Act 1970. Now, the matter hasn't moved further, but based on my reading of patent law, I don't think things are going to change, because if you read Indian patent law also, you will generally notice that it is worded in a manner very similar to the UK patent law. So that's the reason why most probably the result which we are seeing from the first examination report in this application will continue in the subsequent stages also. But again, we'll wait and see. Maybe in another 3-4 months we might actually see a proper rejection coming from the side of the patent office. We will have to wait for a couple of more, maybe months. Similar issues are also raised in the context of copyright. Again, the work which you are seeing on the screen is an artwork which won the first prize in the prestigious Colorado State Fair. But once the prize was announced, the concerned artist mentioned that this work was created with the help of Midjourney. And then later, this particular work was also subject to the copyright registration application, but the Copyright Office in the US rejected that application despite the fact that this work was created through more than 500 prompts. The answer again there was that with respect to copyright also, the author can only be a natural person. So that's a position taken in that area also. In the Indian context also, something interesting had happened. So here, there is an artwork which most of you are familiar with, that is Vincent van Gogh's Starry Night. And then one of our lawyers, a very good friend of mine, Angit Sani, filed a copyright application wherein he claimed that this particular artwork, which you are seeing on the screen, was created by an AI system, that is Raghav, and I think it's abbreviation of Robust Artificially Intelligent Graphics and Art Visualizer. Of course, a nice name, right? But yes, giving credit to him, he had given the full form also there, so that there was no confusion on the side of the Copyright Office as to who is the author mentioned in the application. So when it was filed as an application of Raghav, the Copyright Office rejected it, saying that only natural persons can become the author. But to my surprise and to the surprise of many others, when he filed again the same application, but wherein he also mentioned him as a joint author, the Copyright Office suddenly granted that application. But to me, that doesn't make any sense, because unless and until our copyright statute is amended, you cannot actually do this. So here our Copyright Office was becoming a bit too enthusiastic, so that's the reason why they granted it. But again, I mean, when the matter became a controversy, they said they are revoking the concerned registration. But then the problem is, even if you search with the file number on our Copyright Office website today, it is still there. Because the Copyright Office hasn't been able to revoke the registration. Again, the problem is slightly a procedural one. The Copyright Office cannot revoke the registration. If at all it has to happen, now it has to file an application before the High Court and then get it revoked, which I guess the Copyright Office hasn't done. So what we are essentially seeing here is that, at least in the area of copyright law, India is taking a slightly different approach from what the US or UK has taken in this particular area. But to me, I think it's a slightly adventurous step, which we might have to correct. With respect to the US Copyright Office, again, I mean, they have also given guidelines wherein it categorically mentions that the copyright law as it stands now is meant to protect human creativity, which means, yes, only humans can become the authors. Of course, there are discussions happening in US and many other countries, and maybe in the upcoming years, we might see a change in position. If you are considering AI as an author, we might also have to find answers for these questions. Who can be considered as an author? Should the AI as such can be considered as an author? Or should the programmers be considered as an author? Or should you and me as the end users should be considered as an author? So these are complex questions that cannot be answered easily. Yes?
So given we are getting into machine-to-machine economy,
Yes.
right? And today machines can do transactions with each other.
Yep.
So what if we are giving it? I mean, what is the problem behind it?
Very
Because
important.
at the end of the day, it's all loyalty. If someone is using it, it is that person or economy who pays back some loyalty to it. So what is, I mean, and even if some other work is derived from that work, again, loyalty goes on. So
Yeah.
what is the problem?
So there are two problems here. One of the things which we have to always keep in mind when we deal with intellectual property is every intellectual property has a social cost involved. Because the moment we are granting intellectual property rights, we are excluding the society from using that particular work without permission. So there is a social cost. And we justify that social cost by looking at, okay, what are we getting in return? So in the case of patents, we are saying that yes, we will give you 20 years protection because you are teaching us how the invention is working. So that was a rationale that has been used for granting of intellectual property rights and thereby also bearing that social cost. And we also did that primarily based on the argument that there needs incentives for humans to engage or continue creativity. So if you are granting 20 years invention to madams, for example, yes, we are in a way incentivizing her to continue engaging in inventions, because in the absence of intellectual property rights, madam will also know that yes, the moment she reveals or discloses the invention, others will copy and there is no economic advantage for engaging in inventions. Now, when we look at the AI realm, what we have to ask is AI influenced by the same set of incentives? The general answer with respect to inventions or creations that are autonomously generated by AI is, sorry, that's not the case, because AI doesn't get influenced by these kinds of economic incentives. So that's problem number one. The second problem is also important because most of the AI is based on many copyrighted or other IP protected works. As it stands now, there are around 30 litigations happening in the United States with respect to copyright infringements done by different Gen AI tools, including ChatGPT, Midjourney, etc. So these ones, for example, I mean, you have some of your favorite authors like John Grisham and so on, have initiated lawsuit against OpenAI. In this case, it's Getty Images, and New York Times also has initiated a litigation against OpenAI. In almost all these cases, what is very evident is that they have used enormous amount of copyrighted materials, or in other words, works which are result of human creativity. In how many of these cases did they provide any kind of economic remuneration for the concerned right holders? The answer is close to zero. Of course, I'm not saying there should be, but all what I'm saying is we are in a scenario wherein we can clearly see them using copyrighted works, but without giving anything in return for the concerned right holders. If that's the case, then what justifies IP grant for them? That's also a very important ethical question which we will have to answer before rushing to grant IP protection. The last point which I want to convey there is that, as many of the recent studies have shown, if many of the Gen AI tools, which by now we all are familiar with, have to survive, they have to continue to rely on human creativity, because most of the Gen AI tools which are relying on synthetic creativity are apparently producing absolute rubbish. Even within ChatGPT also, you will notice that the quality has been deteriorating over a period of time, because the moment ChatGPT starts using works that are generated by ChatGPT, the quality is generally going down. So unless and until we address these kinds of policy and ethical questions, we shouldn't rush to grant of IP rights. So that's my general take on that.
So I have a couple of follow-on questions.
Sure.
So one, today most of the governance of these AI models is very centralized,
Yes.
right? And with now advanced retrieval and RAG kind of methods, indeed for every generated response, you can actually go back and refer what are the sources used.
Yes.
And now there are some distributed governance use cases which are being explored, where an AI and blockchain together can actually incentivize, tokenize, and benefit the content creators. And second, Gen AI is like a baby now at this point of time. But eventually, with more and more parameters getting in, the creativity can go beyond our experiences, because most of our creativity is limited to our five senses and the kind of experiences we are able to perceive, right? So in that context, how do you see the future, say 10, 15 years from now?
Sure. So two things, I guess, from October 2022, the time at which ChatGPT was released for the public, I think till now, things have changed in unexplainable ways, right? I think the world before October 22 is, I think, absolutely different, particularly for academicians, because, for example, when we deal with student submissions and so on, we are now dealing with an entirely different set of issues. That's one issue. But many people, particularly, I mean, for example, many of the influential magazines like The Economist generally tend to say that, yes, now with 2022, we saw a huge jump in, say, for example, the inventory landscape in that particular area. But maybe now things might slow down a bit, and as you said, maybe the next jump might happen in around maybe 15 years or maybe 20 years, whatever it might be. That's what at least some of these policy watchers or the tech watchers are actually saying. So that's one thing. If that's the case, then my general response would be that let's take this slowly. Like most of the other jurisdictions, particularly the United States, UK, and so on, what we might need now is more and more deliberations on what are the positives as well as the negatives for grant of IP rights for AI-generated works. With respect to AI-assisted works, I think we can still take a relaxed approach because humans are still at the control stage. But with respect to the AI-generated works, I think we have to take a slightly slow and cautious approach. And that's primarily because of the social cost reason which I mentioned earlier, and also the incentive question which I mentioned earlier. We don't need to rush. So what the Copyright Office did is an absolute mistake. So instead of making those kinds of mistakes, what we might want to do is to take this time, I think the time between now and the next leap, reflect on this, and then decide what approach we should be taking. It was also interesting that you mentioned about the rack model. So at my university also, we are actually experimenting with some of these, particularly in collaboration with firms like Meta. Yes, maybe that might actually be the future also. For example, the project which I am referring to is in collaboration with the Department of Consumer Affairs, wherein we are trying to see whether curated data sets and rack can actually be used in terms of making life easy for consumers like you and me when we file consumer complaints. Again, these are at very initial stages. We'll have to wait and see how things pan out. But till that time, I guess stakeholders need to take a slightly relaxed approach, engage in more deeper reflections rather than rushing into conclusions. Yes. Absolutely. So now let's look at the issue of standards. So I guess for this audience, you had extensive discussion on standards already. So I guess I can skip what a standard is. But yes, it's very important to recognize that standards play a very important role in making our life much, much easier as compared to a world wherein, yes, different people will be traveling in different directions. I think that's the level to which I guess we all can agree to. Now, I think we all also discussed about standard setting organization or standard development organization, if I understand correctly. So I guess I can skip this part also. Now, when we come to the standard essential patents, we are talking about a patent which is claiming technology that is essential to an industry's standards use. So I do not know whether you discussed in detail yesterday about some of the telecommunication standards, but if you are, say, for example, talking about 2G, 3G, 4G, etc., they are all covered by many, many different patents. So if you are an implementer, say, for example, a handset manufacturer who wants to offer 4G or 5G technology on your phone, one of the things might be that you need to get access to the concerned patent. So, sorry, just give me a second. So, should we take a break now? Or? Okay. So, ma'am, I think then let's take a break.
Welcome back, everyone. I request everyone to be seated. So welcome back. We will now continue our workshop on Bharat 6G Vision, translating research to standards, with a panel session titled Standard Essential Patents in Telecom. This session will be moderated by Ms. Madhavi Das, who is Director General, National Communication Academy. And we are honored to have following panelists with us. Professor Arul George Scaria from NLSIU. And then we have Sri Santosh Gupta from as Assistant Controller of Patents, DPIIT. Then Sri Kanda Sami S, VP at MS Signal Chip. And then Dr. Vijay Singh, Manager, IP Tel, IISc. So I invite all of them to the stage, and let's get started with the session.
So a very good morning and welcome back now to this panel discussion. I think before I get into the panel discussion and what we hope to achieve from here, what I'd like to do is a quick introduction of our panelists. What we tried to do with this panel is ensure that we have all stakeholder groups represented. SEPS is a subject which has been a matter of debate, fairly intense debate. So the idea was to bring this debate in a controlled format onto this stage. So I'm happy to introduce our panelist, Mr. Kandasamy, who's from Signal Chip. He's a VP from Signal Chip. You can see his impressive backdrop here. Professor Scaria, who you all heard in the morning and who would be continuing with us. We have Mr. Santosh from the Patent Office. He's come to join us all the way from Delhi. He will bring in that expertise. And we also have Dr. Vijay from IISc. So we've tried to create an interesting mix of academia, technical, and every other stakeholder group. Now, before I make some opening remarks, I would like to ask the panel to perhaps have their initial remarks of about 10 minutes each, right? And that would set the stage for maybe one question each, which I would address to you, and then I'd leave it open. Now, I understand that there were some unaddressed issues in the morning. What we'll try and do is take those issues either up through the panel, or we would be happy to do those after the panel discussion also, either on email or with the panelists over lunch, right? So with these few small ground rules, let me just start with some initial remarks. Unfortunately, we could not get into the depth of SEPS, and because we have an audience here, which consists of an interesting mix of people with a lot of knowledge, people with some knowledge, and people who want to gain knowledge, I'll just mention that SEPS, or Standard Essential Patents, are extremely important, particularly in telecom and the ICT sector. And that is essentially because for standards are required to ensure that interoperability is there. So this is one area where a patent can be essential because it is mapped to a standard, right? To that extent, it is different from other patents. Because once a patent is mapped to a standard, it becomes essential, and there is no choice for an implementer but to pay the person who owns the patent for that use. I hope for the young people at the back, this important aspect is clear. If it's not clear, could somebody please raise their hand? I could make it simpler. Okay, if it is clear, raise your hands. That would be better. Clear only to a few? I'll keep repeating, because this whole panel discussion is going to be meaningless until you're able to appreciate this vital discussion. This difference is critical, right? It is a patent, but because it is mapped to a standard, it's essential, which means for anybody who wants to use that patent, there is a payment involved. So it's no longer a matter of choice. If you are in that industry, if you are in that business, you will end up paying license for that, right? This difference, please understand. What I'll try and do through this panel also is I'll start with Professor Scaria again, so that I'll give you an opportunity to lay the background which you had missed out. I'm sorry we rushed you through that. And I would like to focus the panel discussion on 2 or 3 things. One, I would like to look at what is happening in India. to equally importantly, if not more so, what is happening internationally with SEPs. Because I think there are vital lessons that can be learnt there, right? We will also look at the concerns of various stakeholder groups. That's why we have signal chip here. Because the concern of a small manufacturer or a medium-sized manufacturer is very different from the concern of a larger one. So with this kind of backdrop, I hope I will have all of you involved in the discussion. We will keep our initial remarks short, is my request to the panel, because I know there will be a lot of interesting questions. So Professor Skaria, let's start with.
Thank you, Madhavi ma'am. So I think no one could have done that introduction better, and I'm particularly thankful for Ms. Madhavi for re-emphasizing on the difference between a normal patent and a standard essential patent, because I think that's a fundamental thing which most people forget when they talk about policies or remedies in the context of standard essential patent. So as ma'am explained, if you are an implementer, so imagine that you are a handset manufacturer, and if you want to have 4G technology on your phone, if you want to sell your phone with a 4G technology, if there are standard essential patents relating to 4G, then it's inevitable that you have access to that particular patent or set of patents. I think that's a clarity which everyone should have. And that's very different from the other general scenario wherein you as a manufacturer has endless number of options to choose from. You can decide to go with person A or person B and then adopt their technology. But here, there is a situation wherein if you want to be in the market, you need to get access to the so-called standard essential patents relating to that particular standard. Now, how do we address this particular issue? Because as you can imagine, there are two potential problems here. One, the SEP, the standard essential patent holder, can think that, okay, I don't really like the way you manufacture things. I don't want to license my technology to you. So that's one situation. And one of the very nice ways in which you can do that is asking for unreasonable royalty. So imagine that you are giving the technology at, say, 1% of the net sales value to Samsung, but you are an Indian manufacturer. I don't like you. What I can do is I can ask you 6%. So that's a situation in which we can notice that we have a situation of hold up. That is, the SEP owner engaging in certain kinds of practices which will ensure that you don't get access to the concerned technology in a fair and non-discriminatory manner. A reverse scenario can also happen, that is called a holdout. That is, you as an implementer also knows that yes, this is a standard essential patent, so I need to get it at the lowest possible rate, and I will bargain in such a way that yes, I am asking for a really unreasonably low price, and since it is a standard essential patent, I also kind of presume that the courts or the competition authorities might be in favor of me. So we have two potential scenarios. One is a hold up and the hold out scenarios. So one from the side of the SAP owner, one from the side of the implementer. How do we balance out things? So there are a couple of things that we need to keep in mind. One, if there is a patent which is essential to a standard, then it should be the duty and responsibility of that concerned firm to disclose it during the standardization process. Because whether to include that technological dimension as part of the standard is also determined by many considerations, not just technical but also economic dimensions. And there, the knowledge of whether there is a patent existing relating to that or not can be of substantial importance. If you look at history, you will notice that there have been instances wherein the so-called ambushing has happened. That is, during the standard setting process, the concerned patent holder will not disclose that they have a patent in that area. But once it is adopted as a standard, they will say, yeah, I have a patent, so if you want to practice this standard, start giving me money. The courts in other jurisdictions have tried to address this issue by saying this cannot be permitted, or the competition authorities have tried to intervene and say that yes, this cannot be permitted. In our situation also, this is something which we need to be mindful. So one of the things which every standard setting organization need to have is a very clear requirement that there should be appropriate declaration with regard to any existing patents or patent applications relating to the concerned technology. Whether that is fulfilled at all times or not, I leave it to the rest of the panel, because we also have people from the industry who will be able to tell us more about that. The second thing is having the so-called FRANT negotiations. So the FRANT stands for fair, reasonable and non-discriminatory approaches. So there we are not saying that you and I should be having equal rights, but they are saying that the approach should be fair, reasonable and non-discriminatory, and they have generally left it to the courts to determine whether things are being done on a FRANT basis. There also we can notice that there can be many different kinds of approaches. For example, I as an implementer might argue that the royalty rates should not be on the net value of my product, but on the smallest possible identified patentable unit there, because I don't want to actually pay based on the net value. But the other side might say that no, the net value should be the basis for calculation. Which approach is better? It's not easy to determine. A court has to very carefully take these things into consideration. Another major issue, should there be injunctions as a remedy in this particular area? So as most of you should be knowing by now, as I also kind of indicated earlier, patents generally give you a strong set of rights, and in the case of the normal patents, what generally happens is that the moment you show the court with reasonable, I would say, evidence that you have a valid patent and the other side is infringing it, you generally get an injunction. But should that approach equally extend to the standard essential patents is a debatable question, and there also we have to go back to what man said earlier, that is, if you want to be in that industry, you need to get access to this particular patent, otherwise you are going to be out of the market. For example, is there anyone here who would be buying a 5G phone, who would be buying a phone without the 5G technology now? Most probably you won't, right? Because that's a basic expectation of a consumer. So if you want to be in the mobile phone market, you have to get access to that. And if that's the case, then one of the questions which we have to answer is, do we need to take a different approach with regard to injunctions in this particular area? Maybe one more point I want to add before I hand over the mic to the next person. One of the things which I am constantly seeing in these litigations is that many of these SCP owners are demanding that the other side should take global portfolio licenses. In other words, when Qualcomm is negotiating with me, Qualcomm is essentially saying, take the license for the entire world, not just for the Indian market. But one of the things which we should also ask ourselves is, if I am an Indian manufacturer who is only selling to India and maybe only to Nepal and Sri Lanka, why should I pay the global royalty rates? Can that be demanded as a matter of rights? And would that kind of a demand be in compliance with FRANT? So these are some of the questions, some of the important legal questions that are posed by this particular area, and I really look forward to hearing from the rest of the panel. Thank you.
Thank you for that. Thank you for that very clear laying out of what SEPS is all about in FRANT. I'll now turn towards Mr. Santosh, who is from the Patent Office. In your initial remarks, what I would also request you, if possible, to do is to talk about how the objectives of essentially both the Patents Act as well as competition acts are, in a sense, leading to the same objective, and yet end up in implementation being at cross purposes. So essentially what happens is, because the Competition Act is about ensuring that dominance does not happen in the market, and there is no, or more importantly, there is no abuse of dominance, right? But the Patents Act works towards ensuring that if somebody is bringing in a new idea, a new product, or new knowledge, they are duly incentivized for it. So balancing or harmonizing these two, I think, lies at the crux of what CEPS is all about. So we hope to hear from that in your initial remarks with whatever you would like to lead.
Thank you, ma'am. And good morning to all the audience. And it's a very interesting question with regard to the Competition Act and the Patents Act and how they work. In fact, there are two bodies. One is Competition Commission of India and the other is the Patent Office. So whenever they work, sometimes it is perceived that they are at loggerhead. However, that's not the case. And through this quick presentation, I'll go into this. First thing is that let's discuss little deeper into what is CEP. So when we discuss about CEP, there are three things which is very important. One is standard, essential, and patents. So when we are talking about standards, I think everyone by this time knows that to achieve interoperability, you need to have certain standards like the 5G, 4G, LTE. So there is an organization which is called SSO, Standard Setting Organization. Standard Setting Organization, when standards are defined at that point of time, there are certain things which are called essential. For those standards to be implemented by an implementer, there will be certain aspects, certain patents, which is being held by certain people, which you need to at least utilize. And since patents are monopolistic rights, you need to provide them royalty. So there is no other way to do that. However, there is the moment ACP, the word ACP comes, there is a lot of fear that where it is going to simply jeopardize that particular field. So this particular Venn diagram is with regard to that. There is whole set of patents, there is standards. So there will be certain patents which are pertaining to standards, and out of which there will be only certain smaller amount, certain subset of that which will be essential. So when we talk about ACPs, it's like where all these three Venn diagram intersect. So out of this, like the patent, you see a lot of patents, a lot of standards, and essentiality. When all these three things merge at one place, that is where the ACP comes, the standard essential patents. So sometimes what happens whenever we discuss, we feel like it's like a linear process. However, it's not a linear process. What happens whenever some organization is doing certain research in a particular field, they are pushing the standard setting organization to include it as standards. At the same time, they are also filing patents also. Their objective is not just to have a standard set. Their objective is also to earn royalty by having a good SCP portfolio. So these two steps, patents, filing patents, and getting standards declared, at the same time getting it included as SCPs, standard essential patents, everything is happening simultaneously. So whenever a company like big, they are generally the big organization like Ericsson, to name a few. Ericsson has this kind of thing that they'll go into the research, they'll file a lot of patents, they'll simultaneously go into the negotiations for the standards, they'll get things included as essential also. So we need to understand that whenever even the small organizations, or like right now for the 6G vision, when Honorable Prime Minister was saying, one of the aim is that we need to have 10% of the global patents with regard to 6G technology by 2030. Why? Because we have learned our lessons in a what I should say, in a bitter way. We all know what happened to Micromax, what happened to Intex, what happened to Eyeball. There were a lot of these mobile companies that came. And downside of the ACP was getting highlighted through them. So here the impact would be that whenever, like CEVIT is there in IIT Madras, the Center for Development of Wireless Technologies, and that is Center for Excellence. When they are doing a lot of research with regard to wireless technologies and 6G research, they need to focus also with regard to filing patents. That is where we lack little. So when we have good portfolio with regard to ACP, then we understand how the things are. Now coming to ma'am's question, and that how the Competition Commission of India and everything is working. See, the thing is, whenever we talk about Competition Commission of India and Competition Act, it's like it wants to create a fair field, competitive pricing field. And that is what was tested particularly during 2011 until 2016. So in 2011, first time ACP bombarded Indian industry. When Ericsson said that we object to the handsets which are getting imported by the Kingtech Electronics. And then came a lot of, they were saying that you are infringing. They filed to the Intex, as well as they said it to Eyeball, they said to Micromax, that you are violating our 8 ACPs, 8 standard essential patents. Then they counter filed it into Competition Commission of India. And they said that, see, they are having a dominant position and they are trying to abuse it. Competition Commission of India looked into that and they said, no, this is not fair and it should not be done. And they gave it in favor of all these 3 Indian players, their decision. Then Ericsson went ahead and challenged it into the High Court. Now High Court looked into the matter and said that Competition Act comes into the picture when there is a general concept. But when you have got a specific statute like Patents Act, where you have got provisions like compulsory licensing, which says that if reasonable requirement of the public at affordable cost is not getting fulfilled, government can issue the compulsory license. So there are certain provisions under the Patents Act where compulsory license can also be issued. So they said, High Court said, that in such scenario, it would be the Patents Act which should determine all these type of disputes, particularly the SCP related investigations and the determination of that dispute. Interesting part was that when you look it from the perspective that whether patents or having the monopolistic right is against competition, the spirit of Competition Act, the plain answer is no. Because if you'll see what patent is enabling, patent is a quid pro quo system in exchange of something. Why this particular system was designed? Because the whole human race should not reinvent the wheel again and again. If someone has invented something, the disclosure should be there, and there should be their effort, money, time, energy, that should be rewarded with certain monopolistic rights. And that reward happens with the patents. Competition Act at the same time ensures that certain dominant positions don't abuse this. So ultimately, objective of both of them is to have an innovative market, at the same time have a competitive market. So this is the background through which ACP came, and then Delhi High Court gave decision in 2016 that it should be the Delhi High Court. Then the matter went to a lot of issues were with regard to the FRAND licensing, the fair, reasonable and non-discriminatory licensing. And that went to the appellate division of the Delhi High Court, which recently in July 2023, they gave the decision, which has become a lot of talking point, and it solves a lot of issues. At the same time, it opens a big Pandora box, which needs to be deliberated, which needs to be discussed. So as protection of the ACPs comes. First is the Patents Act under which it will be covered. And then if it doesn't get addressed, then you need to go to the Competition Act. Because you have got a specific statute for this. Then licensing conditioning, that we'll see how it is happening. A lot of executive level and regulatory level deliberation is also happening with regard to how ACPs should be managed, how the FRAND licensing terms should be managed, and what should be the approach. Like in TRI, a consultation paper was discussed. It is being discussed since 2023 to even in 2024 also. And DPIIT also issued one discussion paper, and a lot of other policy level discussions is going on, wider consultation is going on, having certain experiences from the EPO, the European Union, and the US part. So after this, next thing is FRAND. I'll just rush through certain aspects, then we can discuss it further. Though it is named as fair and reasonable, it becomes many a time unfair and unreasonable. Because what should be the royalty base? As it was pointed out, whether it should be the smallest sellable component or it should be the downstream product, main product. Problem with the main product is that it may be using multiple components which are getting covered through multiple set of ACPs. This may result into royalty stacking. You are paying multiple royalties on a particular product. So how to address this is again an issue. Whether this particular practice is prohibitory or not. At the same time, we also have something called TRIPS. India is a member of WTO, and with membership of WTO comes the TRIPS obligation, trade-related aspects of IP-related aspects. So what happens when we talk about TRIPS? It's a international obligation also. So you cannot say that we can have pick and choose type of thing when it comes the matter of IP and globalization. So you need to be in line with the international standards also. So there, when Delhi High Court gave this decision that it should be as per the downstream product, at that point of time, international body was also prescribing the same concept. Right now, there is a wider deliberation going on internationally. When it comes that it should be non-discriminatory, there the ACPs players, since they are big players, they force you to sign something called NDAs, non-disclosure agreements. When I say that the agreement, licensing agreement should be equitable, if I'm having an agreement with say Mr. X and Mr. Y, Mr. X doesn't know what was the deal with Mr. Y. How would it be equitable? That was the question. So they force the implementer to sign a lot of NDAs. There they again have certain prohibitory conditions, like any arbitration will be deliberated in countries outside India. So that's again a question. And the third point is also an important, as what said, that whether it should be the whole portfolio licensing or a region-specific licensing. Region-specific licensing is important because patents are territorial rights. So why you are forcing on the global portfolio licensing? The second thing is whether the implementer, the licensee, was willing or not. And this is a very important question with regard to injunctions, as well as when the term will come for the FRAND licensing, whether it was FRAND based or not. So global deliberations are going on with regard to the FRAND licensing challenges. Coming to SMEs. So SMEs have a specific issue that is particularly with regard to awareness. First is the awareness of IPRs in the field of ICT, and more particularly with regard to ACPs. Challenge here is that if as an SME I want to say develop 6G smartphones, I don't have one particular platform which can tell me what are various ACPs with regard to that, who are the owner of that, how I should negotiate it, because we need to remember that it is a negotiation between two unequal parties. The ACP owner is a big player, while the SME is a small player. So of course the ACP owner is going to have certain conditions which will be beneficial to it, and sometimes very prohibitory, very predatory also. So these type of challenges are there. how they need to be solved. We can learn certain things from the global scenarios. In the global perspective, this is second last slide, so I'm just rushing it. So global best practices, if you see that European Commission has issued one regulation with regard to ACP. They have proposed that whether to regulate ACPs, whether we can have ACP registers. We have patent registers where you can go and see that what are all the patents. But whether we can have some ACP registers where we can have certain conditions that, okay, whosoever is the ACP owner, they should get themselves registered in a particular span of time. Whether we can have certain hand holding for the SMEs, or certain innovative solutions, which is though not part of the global deliberation, but can be like India has in a lot of sector. Like in banking sector, we have something called priority sector lending. Can we have subsidization concepts for the royalty with regard to ACPs to help our SMEs? Whether global obligations, the international agreements, they allow us, do they have that flexibility? And whether we can have a conciliatory services where we can have that alternative dispute mechanisms can be utilized. Before going to the court, let's bring both the parties, help them out so that they can deliberate. At the same time, there are certain things that is happening across the world. Already 6G patent filing in 6G, China reportedly says that they own around 35% of the global 6G portfolio. Similarly, if you'll see the LG Electronics, Samsung Electronics, Huawei, and Qualcomm, they are the leaders in this. So do we have certain scopes for our players to have that? We can have a deliberation on that. And to go with the line what Honorable Prime Minister said while launching 6G vision, it should be affordable, it should be sustainable, it should be ubiquitous. So whether ACP scheme, whatever ACP regime or ACP scheme we are going to have, whether we can have it affordable vis-a-vis the FRAND obligations, those points we can deliberate. One interesting part is, Philips has done a very interesting part. It has nominated its one patent as ACP for 2 standards. How it was possible, say for example, 6G has 16 pillars, out of which 9 pillars are similar to 5G. So if we have good portfolio with regard to 5G, we can leverage it for the 6G also. So Philips is showing certain innovative style of doing this. India is far behind with regard to 6G, but it is increasing since 2022. A lot of patents are coming. So I live with this particular quote from Mahatma Gandhi ji. If I have the belief that I can do it, I shall surely acquire the capacity to do it, even if I may not have it at the beginning. Thank you.
Thank you, Santosh, for that very frank opinion on what is happening in the SAP regime and giving us the background. I'd like now to move on to Dr. Vijay. Dr. Vijay, in your initial remarks, apart from whatever it is that you wish to point out, I would request you to dwell on the issue of essentiality. I think what happens with this sector is that once an SEP comes into play, there has to be a review of its continuing essentiality, because the sector and technology move so fast and it is so disruptive that something that has been declared as an SEP today may be completely irrelevant a couple of months down the line or a couple of years down the line. So essentiality, it's checking. And in particular, because in coming out with a neutral view on essentiality, I feel that institutes like research organizations or academic institutions would have a huge role. So if you could also, amongst other things, dwell on the issue of essentiality. Thank you.
Sure, thank you. So, couple of things before I start. dwell a little bit on my experience with respect to patent filing and the process of SCP from the perspective of patent filings at the institute at IISc, for instance. There are a good number of professors, good number of researchers who are very, very enthusiastic with respect to filing in the telecom domain, and they have a very strong buy-in into this, the story of the growth of India, the story of having better representation from India with respect to the telecom patents, as well as the conversion of those patents hopefully into standard essential patents. However, what I've also seen is the following. They come with great enthusiasm, and very soon the enthusiasm dies down. And some of the reasons are the following. Interfacing with a good drafting attorney, for instance. What's happened, like recently we have been working on 3 specific telecom related patents, and with 3 different attorney firms in India, and all 3 faculty members, 3 different faculty members, they are vexed with the nature of the interaction. And the reason they are vexed is because they feel that they are having to pretty much rewrite the entire patent draft by themselves. And there's a disconnect between the discussion, the technical discussion that happens, and the representation that comes out in the draft. There is a massive disconnect, and these faculty members get very frustrated with that. That is one of the reasons why that enthusiasm to file patents sort of diminishes over time for many of the people that I know, that I work with here. So they're more comfortable with going the way of publication and avoiding the pain of patenting. We've discussed this particular decline, so to say, in the expertise or in the skill of the drafting attorneys with all 3 law firms. I have brought it up with them, and we have discussed. They acknowledge the problem. They commit that we will have better training of the drafting attorneys. They also engage. They commit to engaging the expertise of the faculty members in training their own teams with respect to understanding different aspects of the telecom technologies itself, so that the attorneys don't get bogged down by what they see coming through the invention disclosure. And I don't know how it is with respect to other organizations, but I see at IISc the last 3 patents in telecom, it was pretty heavy on the math, and incredible amount of algebra, incredible amount of complex notation, the matrix manipulations. And what happens, the attorneys, they sometimes sort of hunker down. They get scared looking at all of that stuff, and but the faculty have been very patient in trying to explain, break down the technology. For whatever reason, it doesn't percolate, and the complaint of the faculty members here has been that we make an effort to explain the technology. In the meeting, the attorney acknowledges an understanding of it, but that understanding is not reflected in the draft that comes back for review. And so the point that they try to make is, if you don't understand something, you ask then and there. Make an effort to understand, make an effort to break things down, make an understand to bring out the tangible aspects of that invention. And we all know there's a disparity, or there's a difference in the day-to-day thinking of a drafting attorney, for instance, and the day-to-day thinking of a typical inventor, a faculty member, or any of the researcher. And on our part, that is the IP offices, we've been trying to make efforts to bridge that communication gap. And wherever our skills come in, wherever we can bring in, we try to bridge that gap where we navigate the discussions from theoretical mathematical representations to its more tangible practice, where the idea is the following. Just a single idea at the core, at the heart of it. The image, the working image of the invention, particularly in the telecom domain where we are focused on, the working image must show itself in the mind's eye. If that working image does not come up, then one of two things have happened, or both of them have happened. The inventors have not given a simple enough explanation of the invention. The attorneys and the IP office have not understood the invention. And we try to go with that particular touchstone. Do we have a working image of the invention in the eye of the mind? If we don't, we've not understood. We cannot conceivably work out the patentable steps or the independent claims. And that is one place where we have consistently seen the challenge in getting good number of patents in the telecom domain from the labs into the patent office. That which is important to address. And how do we address it? Of course, it's open to discussion. Couple of things we have already discussed that we have already spoken of. We spoke about essentiality, and how do we measure the perpetuity of the application of a particular invention with an ongoing technology? Left to itself, left to the market, or left to the implementers of the SEPs, there is going to be a disparity in the sense people who own the SEPs, they would want to perpetuate that particular technology, and people who are implementing, they may want to move away from those SEPs. And that is where a balance needs to be created. And like ma'am mentioned, so possibly a role for academia in bridging those communications, in bridging those narratives with respect to understanding what might be essential. And we do have incredible number of people who here in academia in general with very, very deep understanding of the technologies, how they apply, and how they need to modify, what are the different aspects of their application that go into different products. And with each discussion that we have with the faculty members, with the inventors here at the institute, we get a deeper understanding of that. We get a deeper understanding of what is the nature of working of different standards in specific technologies or specific aspects of the technology. With that, I will stop for now. Hopefully, with further discussions, we can dwell on more aspects of it. Thank you.
Thank you, Dr. Vijay. I now turn to Shri Kandaswamy. I think what we would in this house like to hear from you is the MSME perspective, particularly with OTT or with other applications coming in, with a lot of other small players in the market now for downstream or upstream. It becomes extremely important to understand how SEPs affect your position in the market, how it affects your financials, and how it also either promotes or acts as a disincentive to further innovation. So maybe on those lines, if you could help us with.
Okay.
First of all, thanks to the organizers and to Madam for giving us essentially the MSMEs an opportunity to present our views in this. So, as you mentioned, I'm representing the industry over here. So I work for a semiconductor startup called Signal Chip, which makes wireless communication chipsets. Before that, I was with Sasken, which was again in the telecom domain, which was actually a listed but medium-sized company. And actually, the issues faced were not very different, because you have to be really, really big once you are below a certain size. The problems are all very similar. Okay, so I would just maybe I will just 2 minutes I'll take to kind of get into the details of how these things are there without getting technical, right? I think we are all very familiar with mobiles, and you know that when you just switch on your mobile, right, it will first look for, let's say, cell phones, and then it's going to make an access. This is called as a random access, right? Now for standardization and intra-working, those codes are standardized. Now the way this happens is, there are all these companies participating in the standards body. There will be a work group for every area. There will be a RAN work group, and there will be a further work group for access and things like that. And you have to participate in those discussions, and then based on your participation level, right, your position and power in the standardization body slowly increases. So this means that it is a lot of investment which is there, right? You have to keep attending, and these things happen all over the world. So you have to go there, you have to attend, and continuously there is an effort spent on this. And definitely out of the 9 or 10 ideas which are being presented, only a fraction will actually get into that. So you have to keep working on, and it's actually a relatively slow process. When we see that a particular generation has come down now, let's say like 5G has just been there for the last 2-3 years, but the standardization actually started maybe 7 or 8 years before that. And 6G, we're thinking it is starting, but already it has been there for 2 years. So it's a fairly long process, fairly expensive, and also there is lot of politicking as well inside this, because and over a period all these companies also have a certain amount of relationship. Okay, I will back your idea for, let us say, some aspect which you are there, then you back my idea. So you have to get into the club, so to say, right? Now all these are extremely difficult for I think Mr. Vijay mentioned about how it is, even writing a patent is not, it's this thing. But assume that you can get it, fine, you have to do it, and lot of technical people also have that. It's good for their resume and things like, you get in, right? But then getting it into accepted is a totally different ball game, okay, right? In fact, even I think IIT Madras, I think, had this feature called LMLC, Large Area Low Mobility, and the amount of struggle that they went through to get that standardized was, really, if you are outside the club, it's very difficult. And that's true not just for small companies in India. Almost all the companies in India are out of the club. To some extent, even China was out of the club when it came to 2G. And in 3G also, they were kind of not let in, so they split the standard and they had their own TD-SMA standard. And then after that, they were kind of let back in. That's how, there is a lot of backroom negotiation went on to have a unified 4G standard. And since 4G, they have been well into the club, and you can see that they may own maybe 30% of the club, okay. So first problem is getting into this club, right? And it's not that the problem is there only for outsiders, okay. There are, I think Professor Skaria mentioned about these hidden patents, right? There are these things called the submarine patents, which now they can happen by coincidence or by design, okay. Someone is proposing this particular code. Now the requirement of disclosure is there only for the entities participating in the standardization body. And now this can be defined as narrowly or as like the entity in India is doing. There is no requirement for an entity which is not that legal entity to actually disclose what they are doing, or any of their related subsidiary entity. So now sometimes it so happens that yes, this particular method of, let us say that this code which will help in, let's say, some long range cell or high speed cell, somebody is proposing and you disclose your patent. It doesn't mean that somebody else is not silently filing another patent which will, which also infringes, which will infringe on this. You cannot implement without that. And here you absolutely don't have a choice, because that is the code and that has to be implemented in this way for the mobile to actually be identified by the stick. So these submarine patents are one issue. The other part is, while usually when it comes to telecom standards, for example, how to transmit is what is told in the standard, but how to receive is actually not defined, because that is where you are supposed to bring in your own thinking and your own creativity and bring in. But the point is, if you are the guy who is proposing how to transmit, right, you have already figured out the best method to actually decode that, right? So now what you will do is, you will file a patent for the best way to receive that as well, and you are under no obligation to disclose that, because that is not a standard essential patent as well. But now as a SME, you want the best product, right? Without the best product, you anyway, as a small player, you have a tough time competing. If you don't provide the best in class solution, right, that's a big disadvantage for you. The only thing you can do is you can do something technically well, and even there the technically best method might already be patented. In that case, then you have to see something else, which will be tough. It will be designed such that it's not very easy to have an alternate solution which is equally effective. So a lot of creativity goes in not actually solving the problem, but how to solve it such that it doesn't infringe on all the existing patents, whether they are standard essential or not. And I think now when it comes to, I think you also mentioned that probably you can divide that SMEs into two categories. Those who are not aware, so we are here to solve a technical problem, we come in. And the moment you are aware, right, there really is not a thing that you can do today. Of course, long term, there are things you will have to build your own portfolio. So every startup is focused on that, and then maybe one day you will also get your things into that. But those are, and similarly, that will come on the 6G as well. Hopefully, we'll have a much better situation when it comes to 6G. But with 4G, 5G, that is the way. And I don't know if you want to get into the maybe solution part or some suggestions over here. We can discuss that later. Thank you.
Thank you, Mr. Kandaswamy. Thank you very much. And I think he's led me on to the next part of the discussions, which is a solution. I think everybody highlighted their pain points, if I can use that word, whether it was with the researchers who were finding it difficult to file a patent, whether it was with MSME who has pointed out either the inability to participate or even the lack of awareness, whether it was academia who pointed out. In fact, I will probably pick up from there. Internationally, the issue is equally, if I may say, ambiguous at this point. The US, for instance, has a very laissez-faire approach. I think they've just left it without working specifically on SEPs. You have countries like Japan and Singapore who've tried to work on the FRAND licensing part of it and come out with some steps to say that, for it to be treated as FRAND, there must be at least 4 steps, which involves an offer, a counter offer, and only when that is proven, then you can say that at least the FRAND steps have been gone through. But I think the most interesting, or probably the most extensive work which has recently happened is from the EU, as you briefly mentioned. So my question to you, Professor Skaria, is what is it that we can pick up, either from EU or from the other examples, which is not utopian, which is doable, okay, because there are always interesting provisions everywhere. But keeping them in mind, the landscape in India, the kind of business in India, and the kind of problems where we are at, what would be, in your mind, two best practices, maybe internationally, that can be brought to fruition quickly here?
Sure, thanks for that very important but fairly complex question. So, one of the things which I guess we need to understand here is that every jurisdiction which you mentioned is trying to protect their economic interest. So, when we are talking about India or when we are talking about Global South, I guess we need to be mindful of the fact that most of the discussions that have happened or which are taken as a role model are designed by taking into consideration the economic interests of their industries, their countries. So it may not be a wonderful idea to actually imitate that approach. I was kind of surprised by the fact that you didn't mention South Korea and China in your list of examples. And I'm also kind of surprised by the silence of these two, or silence relating to these two jurisdictions in most of the discussions that happen in India. And it's not too surprising because most of the discussions on SCPs in India are sponsored by those who have very vested interest in terms of protecting standard essential patents in India. For most of the research, academic research in this area are funded by Qualcomm. Many of the things, litigations are led by Ericsson. So that's also very interesting dynamics here. So you don't see Qualcomm litigating here. Has anyone seen a litigation from Qualcomm in India? No. And always the litigant is Ericsson, but on the backside, academic research is heavily funded by Qualcomm. And how many of our academic researchers have disclosed the funding they have received from Qualcomm? Again, these are problematic issues. So one of the things which I, as an academic, would suggest is we need to support more research in this area, and I think Department of Telecom is very much well placed in this particular regard to lead the discussion, because as Madam, I think one of the key words which I could gather from Madam's earlier remark was neutrality, right? You are talking about neutrality in the context of identifying what is an essential patent. I would generally extend it to the policy making in this area. I think we need to have more neutral players coming into picture and evolving an indigenous approach to policy making in this area. And again, this wouldn't be like completely unprecedented. If you look at the history of pharmaceutical industry in India, why did India become a pharmacy of the Global South? Did it become a pharmacy of the Global South by imitating the foreign jurisdictions? Absolutely no. We went with our own indigenous approach in this regard, and we developed our own policies which are now also helping considerably the Global South. So in a nutshell, my response here is that EU path, definitely no. Maybe we should look at other countries from the Global South, evolve a consensus, and most importantly, and as I think Sri Kandasamy was very rightly pointing out, in an indirect way, we need to build capacity in terms of participation in this forum, because I don't think we can live in isolation also. It's very important that we participate in these forums, we contribute to the standards, and that can only happen with lots of effort internally. So more capacity building in terms of participation and making our voice heard is the most important step in my opinion.
Thank you very much. Mr. Santosh, I think with you I'll have a slightly more factual question. The Indian Patents Act has absolutely no mention of SEPs anywhere at all. For that matter, nor does the Competition Act. So SEPs as a term or as something that is gaining more and more traction, and with our vision of having 10% of 6G patents coming from India, which has to happen in the next few years, as Mr. Kandaswamy pointed out, we are already perhaps a little behind in the race, so we have to pick up. Is there a case for relooking at these areas and finding some viable way of at least acknowledging SEPs, either within the acts or the rules or the guidelines or in some other fashion, which will then assist the judiciary when cases come up? Because cases will come
up. Thank you, ma'am. It's an interesting question. Right now, SEP has been dealt in India mostly with regard to the judiciary. So if we see from 2011 onwards until 2023, There has been a lot of discussion with regard to SEP, and it has emanated from the judiciary side. There had been a certain level of implicit acknowledgement when DPIIT floated the discussion paper in 2016 with regard to SEP. A lot of deliberation is going on with regard to that, because I would say ill effect of the ACPs, we could see what happened with the Indian telecom companies. And yes, it's a time when there should be more clarity. However, government with regard to ACPs is having a little cautious approach, because even in the foreign jurisdiction, it is evolving and it is changing every time. If we'll see even in the Indian jurisprudence, it changed. What was the logic for the FRAND in 2016 got changed by 2018, which again got changed in March 23, which again got changed in July 23. So everything is like a flux. And when government want to intervene with regard to the Patents Act and everything, it needs to be doubly sure with regard to this. Certain aspects with regard to how the things are evolving in India, I can say that it's evolving in a pretty positive fashion, particularly because I have dealt with certain patents of IISc also and SEVIT also. And I'll share what you were sharing, that sometimes translating a technical specification into a techno-legal specification by the attorneys, the technical aspect gets diluted. So in one of the hearings where, and it was very good that one of the professor appeared for the hearing, and I was taking the hearing, and when he explained it to me, and since the patent officials, they are from the technical background, so we have got that patience. Okay, whatever you are explaining, I'll hear it. Attorney may not have that patience. So certain solutions that can be like whether we can have certain in-house IP wing, a small in-house IP wing, whether we can approach instead of directly approaching to the patent attorney firms, which is more in the legal aspect, to the IPFCs who deal more with the technical aspect as well as certain legalities. So with SEVIT, I would say, when this type of conference happened in May, 17th May this year itself in Delhi by the DOT itself, there I was a speaker for one of the session, and I had an opportunity to meet the person who is heading SEVIT. So he was explaining me certain things that they face, the challenges that they face, that attorneys may say that this is not granted. I said, no, it's not, never like this. So he said, I have been told that it is not granted. I told them that I am the controller, I know that it is granted. So a lot of misconceptions happen. But brighter side of the things are that things are changing for the positivity. If we'll see that this was not the deliberation that was happening, so ACP has come to the picture, slowly we may get into the things. Last point is with regard to SMEs issues. It is not that it is just confined to India's SMEs. If we'll see the problems of SMEs, it is also for a lot of other countries also, because SMEs are the main employment providers. However, when it comes to the big technical wars, particularly like ACPs, such challenges happen. So they have got certain concepts like proof of concept approach, where you make the certain things get patented and license it to someone else, allow the other organizations to face with the ACPs. So that is one of the way to tackle those things. So, and the last one is we can utilize the concept which ACPs suffer is over-declaration. These companies, they go to the SSO and they say that the whole portfolio is with regard to the standard essential patents. However, only a minuscule will be relevant. So we can utilize that also, because there is a difference between what is published and what is granted. So that's my take.
Thank you, Santosh. Dr. Vijay, in fact, I will probably repeat the question I asked Professor Arul Skaria for you, because I am not perhaps in complete agreement, with all due respect. I feel if there is a best practice which can be customized and used, or even if not a best practice, a thought at this stage which can be customized and used. For instance, something like having a register as a SEPS database, because that takes care of a major problem of information asymmetry. Today, we do not have a one-point database which can be approached by SMEs or MSMEs anywhere, or anybody at all. So even when they're violating SEPS, they may not even be aware that they're violating SEPS. So some of these kind of initiatives, is it possible to think of certain things that could help the industry, the researchers, etc.? Just one or two of your thoughts on this off the cuff.
Yeah, I agree with you and also disagree with him. Sorry. No, see, globally our problems are similar, our solutions have shared similarity, and there are a lot of best practices we can adopt. Of course, having a repository is one. The second is what might be referred to as collective bargaining. In India, what happens, one institute does not talk to other institute, the academia and the industry don't talk to each other, which is very different from many of these countries which are very, very strong in SAP representation. We need to have that collective bargaining, so to say, where institutes unite, institute and industry unite. And I think yesterday also someone brought up this point where we need to all work together and decide among ourselves what is it that we want to push as standards. And these are part of the global best practices that we need. We need to have a higher number of patents that we file in the telecom domain. It's part of the best practices globally. Yes, I will stop with that.
Thank you, Dr. Vijay. My last question, and then I'll throw it open to the floor. I'm sure there are many questions. Mr. Kandaswamy, apart from obviously wanting to hear from you on possible solutions which would address some issues raised by you, I would also like you to reflect on whether there is a case for standard-setting organizations to revisit their own processes. Because at the end of the day, one of the major stakeholders who are completely self-regulated and do their own setting of standards are, in today's world, for lack of a better word, not as transparent as they should be, right? So the processes being followed, maybe not listed as well as they should be, or having some kind of code of ethics. I'm not talking of external governance. I'm also talking of within the system, some kind of transparency measures, etc. Is there a case of that? Please reflect on that, and also, of course, what would be your idea for solutions?
Yeah, interestingly, the point that I was about to talk about was directly what you were asking, okay? So, okay, first a disclaimer, now the views that I'm going to present are my own. It's not necessarily, represents Signal Chip's position, okay, because some of this may be controversial, okay? So I have seen the standards in 2G, 3G, 4G, and now 5G, okay? One thing that I really remember well was that the standards were remarkably simple in the initial 4G. The initial release of 4G was something which, as a technical person, you can even admire, okay? And there was only one reason for it, one and only reason for it, okay? That is the time when it faced competition from another standard. See, basically, of course, there is a whole XKCD thing about, okay, there are so many standards, now we should make a new standard to unify all of them. What happens? You don't want multiple standards, but at the same time, having only one standard also is a kind of a monopoly, right? But in that 2007 time frame, okay, there was these, we had the WiMAX, which was basically you take Wi-Fi and add mobility and keep it as simple as possible and then do that. And there are a lot of, in fact, even BSNL actually rolled out WiMAX partially as a standard. It was really snapping at the heels of actually IEEE and the computing world is one set of standardization. Anyway, I don't want to get too much into it, but what I was saying was that brief period of competition between the standards actually really helped. Now it's a question whether you want to, actually have competition. Standards is a different thing, and then you can also say that, okay, even if you create a new standards body, that may also go down into into this path. Okay, but I kind of feel that apart from this, right, having some option where something else can come. Already standardization is a very, very difficult process. It's like herding cats, because everybody is a strong technical background, they come in and then they on top of their own interest. I really don't know whether this is something which they can, you already have the disclosure, you already have this thing, but I feel that there is, maybe they can do something, but that's not going to have the major impact, right? It should really come from regulations, right? That is one thing, right? And just for the immediate relief, right? I think Santosh already mentioned that one way in which you can do is if you are a small person, you are making and building the solution. We call this as the the biggest fish in the chain does the negotiation. So all that the small fish will say is, I'll give you everything else. I know that I give you my copyright, my patents, everything, and I will give you indemnification for non-standard essential thing. But standard essential thing, I will have to infringe, and that I cannot do anything. You go get the rights and we pass it on. And this slowly goes up the chain until the biggest person, until it reaches biggest solution. So this is how it is working now in the industry. Okay, for the SMEs who are aware, who are not aware, they are all sitting on a. But it does not always work, because sometimes if you are giving solutions for, let's say, some small scenarios, you give an operator, yes, it's a bigger solution, but you may also give it for public safety. You may also give it to the army or defense and railways and other things where there is not necessarily a big player in the chain. So there, this issue is still there. That will help. And I think already mentioned about the registry. So that's a good first step. But the subsequent step has to be to say that there has to be an India-specific pool which has to be given, and the government should use the levers that they have to bring the holders to that. One lever is, which I have suggested in multiple forums, is definitely the market access, right? Because when it comes to communication, it is also a strategic facility, and here you can always say that you want access to this, then you need to do that. Then there will be the question of, there are all these non-practicing entities that I don't do business in India, so then how will you force me, right? Actually, I know that Indian patents has a concept of working of a patent. You have to file periodically that how you have worked the patent, and if you have not worked it, it automatically can go into compulsory licensing. That's a simpler. So government does have some tools in its kit, and they can use this to force these existing holders to come to the table and negotiate and start up a realistic and true, fair and reasonable licensing from this pool can be done.
Thank you. That's very interesting. I'd like to now throw the floor open for questions. If you could raise your hand, anybody who has a question, and introduce yourself. Can we pass the mic around?
From the discussion, what I have, my mind is clear that patent is basically national activity. Like India has a patent act, United States has, European Union has. So every country or a group of countries are into patenting. Similarly, standards are being made by international bodies. Say ITU is making 3GPP, or there are some organizations, international organizations for various levels of standards. But who is taking decision on making them essentials for a particular sector? Is there a body? Is it the standard making body, or how is it happening? How does one standard or a patent, the intersection of the two, as Mr. Santosh rightly was showing, that the common area, standard, patents, essentials, is the area where SEPs play in. So who is taking decision on the essentiality? Maybe Arul Skaria or anyone? Yeah, thank you.
Yeah, it is, short answer is it is the standardization body. When it comes to telecom, for example, a lot of it is 3GPP. See, I started with that example that, for example, if your mobile has to register, it has to send a particular known sequence, right? And if you see in communication theory, there are multiple codes which are possible, some work in some situations and things like that. You can take these and you can modify them and say that this is good for all these things. Now, when it comes to what goes into the standard, there is this work group which is represented by all the members of that, which is again primarily the industry and also academic institutions and research institutions. All these people come together and say that, okay, for the mobile to tell the network that I'm here, give me the registration. This is the code that we want to put. Now, as I said, a dozen solutions will be proposed. And this group, right, this group there are office bearers of 3GPP who are again from the industry and the academia and other things, who throughout their years of participation held positions of power, okay, and with that they are able to direct the thing such that a particular standard is selected, right? So yes, this will go into the standard, right? Then the moment that is put into the standard and it is published, then everybody else has to follow. Now, all the participants would have disclosed the patents that they have. So, whichever idea is selected, there will be a list of patents which have been disclosed. So, they automatically become, and once they are ratified, there will be again, which goes from proposal, goes through its own decision-making process, and finally, when the standard gets ratified, those patents become the standard essential patents.
Just to add on that, essentiality of a ACP is a challengeable thing. It's not like holy grail that if SSO has said that this is ACP, in court of, say in Indian scenario, in the court of law, in the high court, someone can challenge that though it is claiming to be ACP, but it is not the essentiality is not there. It is not the ACP actually, because there is a lag between when it is getting declared as a ACPs and what actually is getting granted in a particular jurisdiction. Patent is a territorial right. So when it was getting declared, say in EP, in Europe, if it was getting declared as a ACP at that point of time, there whatever was granted may be a broader thing. However, in India, by the time if it gets granted, if it is a narrower thing, so it may not form a part of essentiality. So it's a challengeable thing.
So I think first let me put my question, and then probably I may supplement what was asked to. So question is to all the panelists, probably Dr. Vijay may be able to throw some light, or maybe Professor Zakaria, because the question is, we all feel that there is a requirement of having a SAP register, maybe globally, maybe nationally. So, which is the right place to create such kind of register? Should it be within the governmental framework or the, you can say, non-governmental kind of the industry stakeholders purview, right? Because once it goes government, then it has to be the UN body, maybe ITU or somewhere wherein this can work out. And if it is non-governmental, then the definitely other side is there. So we would be happy to have your views, to listen on that. And just to supplement, I think the beautiful question with respect to how the essentiality or the common part of the essentiality standards and patents come in picture. My friend from the signal chips has rightly said, but for the rest of the people who may not be able to understand the entire process, in the mobile telecommunication domain, the entire business of SEPs, non-SEPs, standardization, everything is taking place at the 3GPP, which finally gets endorsed by the ITU. Now, 3GPP is a consortium having 6 standard bodies, okay, wherein we have Japan's body, there is a body from the US, there is a body from ETSI from, they say, Europe, our neighboring, as well as we have the presence of the Indian entity called TSDSI. So my request is anybody who is a smaller company or the SME or anyone, they feel like there is anything which needs to be represented at 3GPP, since the government of India through DOT is putting entire cost being borne by us on behalf of the TSDSI, we would like to take up that matter at the level of TSDSI, or I should say through the TSI, and once it comes to the ITU, we have the United Nations platform. So at the diplomacy level also, we would like to take up that issue. And be sure, whatever the difficulty we faced in the 5G and all, you are not going to face. Another thing is, if there are differences, what happens? So what happens in that case, the essentiality is defined in the multiple ways. So for the 5G, we had 5G-I standards, we have 5G 3GPP standards, and 5G NR standards. So that means if there is no commonality, though no consensus, there could be multiple standards. And then whichever you want to have, you can have it. Only thing, they understand once multiple standards goes, the revenue return are not there to the big fishes as we discussed. So finally they come to the negotiation, and that is the way how the LMLC and the other things, 5GI got converted to the final 3GPP thing. I think that was just for the information sharing. Thank you.
Thank you very much. Any other questions? Here, please. One here, and then one, there's a student at the back.
But maybe, ma'am, if they can answer.
The correct place to house the separate register.
Yeah, so why are we talking about SEP register? I think, so we have to actually take that one step back and then ask, why do we even discuss about having a register? So in one of the initial remarks, one of the panelists mentioned about non-disclosure agreements, and one of the things which everyone who is sitting here should be aware of is the fact that it is a very common practice, or it has become a very common practice in this industry to demand signing of a non-disclosure agreement, even to let you know which patents you are actually infringing. Under which law are they doing this? Because patents is a public document, and if you are an implementer, isn't it your right to know with clarity which patents are being violated by you if you are going to incorporate this standard into your product? For that, you don't really have to create a SEP register. All what you need to do is enforce the provisions of the Patent Act in its full spirit. So someone earlier mentioned also about the interface between competition law and patent law, and as he mentioned, the Competition Commission had to kind of like step back because the Delhi High Court said, oh, there is this Patent Act, which is a specific legislation which is well equipped to deal with all these issues. So Competition Commission should at least not deliver its verdict. So they didn't say they shouldn't investigate. All what they said is investigate, but don't give the result till the time we tell you. The question is our patent office really doing its job in forcing the SEP owners to disclose all the patents which are being violated within the territory of this country? The clear answer is no. So all what we need to do, instead of like spending our time on creating a new register, all what we need to do is to tell the SEP owners, if you really want to enforce your right, at least tell the implementers, these are the list of patents which are being violated by you. So my simple answer there is, let's not waste on our time on creating a new list. All what we need to do is tell the world which patents are being violated. It might be 1,000 patents, it might be 10,000. Let the attorneys go through it, and I think that's more than sufficient. And again, I want to reinforce the basic thing here. A patent is a public document. There is nothing confidential about it. If we are talking about royalty rights, I have no problem. Yes, put it under a non-disclosure agreement. But if you are talking about the list of patents which are being violated by me as an implementer, I have the right to know which patents are being violated.
Yeah, so I think just to enforce that right and ensure it is available at a common point and easily accessible, perhaps that's the thought behind the register. But let's leave the thought. We have a lot of questions.
Yeah, thank you panel for this wonderful discussion. I could sense India's own narrative building up on SEPs. Now, referring to the this diagram which DPIIT just showed to all of us, very exciting thing, where we saw in, this 3 circles of standard, essential, and patents. So on that, what I would like to say is that actually there is no intersection at all. Standard is getting forcefully brought together with essentiality and patents. Standards are voluntary in nature, and they are supposed to be followed by all countries for interoperability, a very pious term, but now with the advancement in technology, it may be possible to ensure interoperability through different solutions. And thinking that a particular standard can be implemented only through one particular patent essential and making it as a essential to that standard is, I think, not in order. And somewhere I think I agree with Professor from sir, what you mentioned, that India should come out with its own solution, as many other countries have done. For example, Japan or China. Thank you.
Was there a question there somewhere?
No, madam. What I mean to ask is that somewhere we are all the judgment which we have just discussed today. Somewhere I think we have just borrowed the narratives of dominant players. So I think this is just a thought, not a question, madam. Thank you, madam.
Thank you very much. There was a question at the back somewhere.
Good afternoon to the panel. My name is Rohit and I'm from PS University. And one thing I've understood from the discussion is that standard essential patents are very important to anyone who wants to enter the market. So one thing I was thinking about is how is that a small business will be able to meet the demands of such SEPs? Like how does a small business try to enter the market if the demands are, there's so many patents to be fulfilled. So how is that like a startup or something that's very small with not much funding be able to fulfill these demands?
Affecting these youngsters.
Yeah, so we'll expand on the answer which we have already given, right? See, when it comes to standard essential patents, if you are working, if your startup is in a domain where you have to implement what is given in the standard, there really is no choice. I mean, other than questioning that essentiality, which Shri Santosh mentioned, that is a different thing. But establishing that is also not an easy task for a SME. Okay, in fact, even it's almost as difficult as challenging a patent. Okay, and these people who are doing this, they have been doing this for decades. They know what they are doing, right? They know that they throw 10 things, at least 8 or 9 of them will stick. So essentially, there is no mechanism. You will be, if you are, you can, one thing you can see is, you can see if you can skirt around that, right? You can see if you can, if you need not implement that part of the standard, that's depending on your startup, right? You may or may not have the option. But the moment you are, you have to, as part of your technical solution, you have to implement something in the standard, there is no option. Right? That is how it, that is why we are sitting and debating all this, because otherwise the choice is there, right? In some sense, otherwise you have the freedom, right? If you are, let's say you are doing some solution in, you know, I don't know, e-commerce or some of the other domains, right? If you are not doing in a telecom domain, in any other domain, it's actually far easier to avoid standard, because you can, there are 10 ways to do this, and all of them are reasonable. There will be trade-offs. There will always be an engineering trade-off. But here, what happened is, out of those 10 ways to do it, one has been fixed as the standard for interoperability. That is where the problem is. So you will be violating it, and the correct and legal way right now is that you when you give your solution, you give that with the awareness that this is not there, therefore I am not giving you the right? So if you have to use it, right, then you have to obtain that. Now the other way, what if you are yourself as a user are providing it as a service, right? Then you don't have a choice. Otherwise it's like a sword hanging on top of your head. If you make a hardware solution product, something, you give it to a service provider, let's say something like a telecom, you can use the mechanism which we discussed about, saying I am giving you everything other than the standard essential patents. That alone you have to go buy and then get it. So that is one solution. That solution works a lot of times, but where it doesn't work today, really there is nothing in the medium term. So, but for the non-essential things, you always have to put your extra creativity to see how is it that I can not violate that. For the non-essential things, you can do that, and in that process, most likely what you come up with will be patentable. So make sure that you actually do patent it, right? So there is I think there are multiple ways when it comes to patenting and things like that. But it is not, I would say that today it is not as difficult as it was, let's say, 10 years or so. Okay, it's, you can find people who will help you, and there are cases where maybe you do all the work and do the drafting, everything, and they will just go through the actual legal filing steps. That can be, because in the end, even if you go through someone who giving you the drafting service, practically you will end up doing a lot of the drafting yourself. And at least in Signal Chips experience, that's how it is. We do most of the drafting and we go to someone who just helps with the filing. So that way it's economical to get it. So when you come up with these creative solutions, patent them. These are the 2-3 things you can do today to.
Thank you for that very positive answer. I think showing them the way is extremely important, because we don't want to kill their enthusiasm for, patenting or creating. There was one question this side. Can we have the mic that side, please?
Just one question was regarding the SCP register. I have a question. Anyway, you are maintaining a patent register. Is it not possible to add a column to showing this patent is essential patent? Yeah.
It's not as easy as it sounds, because see, maintaining SCP register itself is an implicit way of saying that it is an SCP. Why would, as authority, you would muddle into that? So that's a conscious decision that everyone need to take. If it has been so easy and so straightforward, we would have got a lot of example of SCP registers. But see what happens when it goes to the court. Of course, whenever someone will challenge you, you'll go to the court of law and you'll say that it is not a SCP. Now there is one register maintained by the patent office itself that is saying that it is a SCP, right? So the SAP owner will say to the court, why you are going into that? See, patent office itself is saying that it is an SAP. So there are certain tricky points which is still getting deliberated. Like I gave it an example of European Union has proposed one solution for handling this SAP thing. And they have said that it should be the patent office, their EPO should maintain a ACP register, because it's easy. It sounds very easy that have one more column. But it has been 1 year, it's still deliberation going on. They have not implemented it yet.
That's because it's not passed.
Exactly. So there are so many things that goes out. Of course, once it is decided that, okay, go ahead with this, implementing it just like adding one more column. But whether we want to have that, it's a policy and strategic decision.
Okay, thank you.
This can come in the working statement, they can declare, because we are only declaring what we are earning, we are commercializing or not. So they can declare whether it is an SCP or not. So then the patent office may not be have the responsibility, right?
There are a lot of options, even with regard to Form 27, that working of a patent. One view is that they should explain it what they are earning. At the same time, the people who are holders of the patents, they say that your ecosystem of business is not so fast that within 2-3 years we'll commercialize it. So we need more time. So there is one group of stakeholders who want this particular provision to be diluted. At the same time, there is another group of stakeholders who want this particular provision to be strengthened. There is a third group of stakeholders who want that AI ML should be utilized so that this data comes on the website and everyone is able to see that which patent is getting how much commercialized. So there are a lot of competing end to it. I would say that a lot of policy deliberation is going on with regard to SEP. And we'll see sooner than the later, we'll see there are certain outcomes that come. There are certain things which cannot be disclosed upfront, but yeah, it's going on internally, but there are a lot of competing things that is going on. Form 27, whenever you'll have with the academic discussions, you'll see that everyone will go gaga over Form 27. When we interface with the industry says, do you have such a good ecosystem of starting business in India that you are asking right from the first year that give me the data, how much earning we are having? So there are competing ends, but yes, there are certain deliberations are going on that how to get it corrected. Thank you.
Sir, if, the last question that we take.
It's information. If I am the inventor having some invention and I am interested for patent, so how to choose different patent systems are there in Indian, US and European patents, and how to decide it, and whether it needs to protect for different patents or a single patent will protect that material or invention? So.
Simple answer is where your business interest lies. So wherever you get the patent, why you are getting the patent, so that anyone who wants to infringe your patent, you can sue that. It's a monopolistic right, but it's a negative right. You want to exclude others from selling, purchasing, selling and applying that particular thing. So wherever you are having your business interest, you should get patent in that particular country. It's a territorial right. There are ways to file it. There is an ordinary way that you go to that country. There is a conventional way where you get 12 months. There is a PCT route. So those are things, but those things become immaterial. First thing that you need to decide that where my business is. If I am not interested in going to US market, why I would have patent in US? So a lot of these things.
who's the contributing authorities so that we have a fair and neutral stand towards our policy and it is not biased.
Just one liner. Yesterday we were talking about consensus and today we seem to have lost it. How do we reach there?
No, I think there is always a unity in diversity in India. And as you were asking about the FRAND and SEP, see, when the discussion paper was published, comments are invited from all the stakeholders, from even public, everything. Every comment is, people go through. So when government takes a decision, it's more of how it is taken in the telecom policy or these things. That it goes in the public domain, comments are invited, all the stakeholders, private, government, individuals, public, academia, everyone give their comment. Then it is one more, you can say deliberation happens with everyone, 2-3 rounds of deliberation, and then the policy comes. This happens, I think, with every department of government of India. This is a standard practice. And this is how even in patent office, the guidelines that are utilized. In the morning, someone asked about the subjectivity and objectivity. There we have guidelines to bring out certain objectivity, because law is always subjective.
And
So
I think one last word, if I may, as a moderator. At the end of the day, until you're honest and lay the issues on the table, you're not going to get a sustainable solution. So I think there is absolutely no harm in having this kind of honest stakeholder discussion. And I think this panel has fulfilled that beautifully. I would like to thank all my panelists. So thank you so much again, and a solution will emerge, I'm confident. Thank you.
So thank you to all our speakers and moderator, Ms. Madhvi Das, for such an insightful panel discussion on SAP in telecom. I would now like to invite DDG Abhay Kumar Singh sir to the stage to present mementos to our esteemed panelists as a token of appreciation. Abhay sir. Everyone please wait for just 5 minutes. Yeah. So we will go in order. Dr. Vijay Singh sir, if you can. Santosh sir, if you can. Professor Arul George Scaria sir. Also, we would like to thank him for the excellent presentation he gave in the morning. And then Kandasamy sir. Thank you to all the audience, and we will now take a break for lunch. The lunch is arranged at the same